Blue and City of Greater Geraldton.
I object to him too. The application is by the registrar, not by the Shire. It is to do with Supreme Court rules, nothing to do with the Local Government Act.
Just very nice.
Before the court.
Just
An
very
application
nice.
by the registrar, strike out an appeal. The registrar should be here, and as she's an employee of a company, should be represented by a lawyer, not this person. That's your rules.
Mr. Blue,
Not Mr. Blue, sir, it's Wayne Kenneth Blue. You've got a declaration in front of you, and please abide by it, call me by my correct name.
thank you, Mr. Blue.
You will not, sir. That's not my name.
Well, that's the man I'm going to see.
I'm sorry, sir, you can't refer to me to a corporate name. That is a corporate name that is ruled by Justice Callboy in this court on the 23rd of June last year.
But Mr. Blue.
I'm not Mr. Blue, sir.
Who are you?
Wayne Kenneth of the family Blue. That is my name. Please use it.
The notice was a registrar's notice to attend to the parties, and the respondent is entitled to be here. We have read the papers. Is there anything that you wish to add to what's contained in the material you put before the court? You've put in an appellant's case. There's an appeal notice.
Sir, I challenge the authority of you to sit in this court and this so-called court, and you must deal with that challenge. A court is an assembly held under the sovereign.
You haven't put any submission.
I don't have to have a submission in relation to the validity of the court, sir. You were aware of that.
I'm referring to the application which is before the court this morning, which is the registrar's notice.
I'm not bound to that application. It's made under rules which are unlawful, sir, contrary to the Constitution.
You haven't put any submissions in?
I don't need them, sir. I repeat that.
Right, you haven't put any submissions in. Very well. Is there anything that you want to say orally in respect of the application for the court this morning?
Yeah, I mean, just a document to it. That says you're got an ABN number, sir. You're an officer of a company, an employee of a company. You are not an officer of the Crown. Michael Kirby ruled that in Sydney City Council versus Reid, 1996. You can't be an employee of a company and an officer of the Crown. You are required to be an officer of the Crown, sir.
Well, we've read the papers.
I'm not interested in the papers. This is a submission in relation to your validity to sit in this court, sir. Can you hand in this document, please?
And the submission, don't hand up any more documents, Mr. Blue.
Why, don't you want the truth,
What
sir?
is the submission in respect of the jurisdiction of the court?
That you're an employee of a company,
All right.
the Department of the Attorney General, which is a subsidiary company of the State Government of Western Australia, which is a subsidiary government company of the Commonwealth of Australia Proprietary Limited. This document says so. Do you want to see it, sir?
No.
That you are committing fraud by being in this court, sir.
Is that your submission?
That you're committing fraud, that's not a submission, it's a statement of fact of law. Please abide by the law, sir.
Do you have anything else to say on that particular point?
Yes, I'm a certified Commonwealth public official, and I must warn you, sir, you will be charged if you continue this farce. This is not a lawful court. You know it's not.
All right. That's your submission. Very well.
No, that's a statement of a fact. You can't continue, and you can't listen to this person who is not the person who has the application before the court. It is a registrar, sir. This court is sitting unlawfully, sir.
All right. Well, your objection's overruled. We'll move
You
on.
can't overrule an objection to the validity of a court based on a fact of law and the Constitution, sir.
I'll give you one opportunity further, Mr. Blue, to make any submissions you want to make in respect of the matters which are set out in the registrar's notice to attend.
The registrar is an employee of the same company as you, sir. Therefore, you have a conflict of interest sitting in that matter, sir.
All right. That's your submission in respect of the notice to attend?
No. That is a fact of law which prevents you from dealing with this matter that is in our court, which belongs to us, the people, not you, an unlawful judge. You're impersonating a judge, sir. And you can't deal with that because no judge can sit in judgment of his or her own cause, sir.
Well, you're repeating yourself now, Mr. Blue. Do you want to say anything further in respect of the matter which is set out in the registrar's notice to attend?
You keep repeating the same thing, trying to put forward the idea that you have the authority to sit here when you cannot produce one shred of evidence that says you're an officer of the Crown, because, sir, you are not. You're an employee of a company. You are not an officer of the Crown.
No, we've made that submission several times.
Well, I suggest, sir, that you leave this court, because if you don't, you will be charged.
You do not need to repeat it. Is there anything further you want to say in respect to the registrar's notice to attend?
It's a load of rubbish. It's unlawful. It's made by an employee of your company, who you work for, sir. And it's invalid. And so are you sitting in this court, sir.
Ground 8 of your grounds of appeal say that Justice Birmingham was wrong in law and fact when he read out the decision of the court that he did not make all right. What is that a reference to?
It's a reference to the fact there was a gentleman rather heavily built, sitting here in the court, typing things onto his computer, sending it to somewhere else. I watched Justice Birmingham right throughout the whole case. He wrote down nothing. And then he read from a decision that was not made in that court. It was made by somebody outside the court because it made reference to the issues I raised in the case. And at no time did he write down anything. So he didn't write it prior to the case because it involved issues in the case. And I revealed to him a serious offence. And that's fraud. I asked him if he sat under Chapter 3 of the Constitution. He said yes. When I revealed, and he said Chapter 3 of the Constitution, that's in the transcript. And he stated, sir, that he did. Then when I said under Chapter 3 of the Constitution, Section 76, on page 791, the last paragraph states, and I quote, any court of competent jurisdiction can declare a law of the state of the Commonwealth to be invalid by transgressing the Constitution. Section 35 of the Magistrates Court Act says prerogative writs of mandamus, prohibition and certiorari cannot be issued against officers of this court. That's the Act here. Well, this joke here. And Section 75 of the Constitution says prerogative writs of mandamus, prohibition, certiorari and habeas corpus can be issued against officers of the court to command them to do things they are refusing to do and force them to stop doing things they shouldn't be doing. Now that means that the State Act, the Magistrates Court Act, and obviously any decisions made under it, including the one that's before this court, is therefore invalid. Now, as a judicial function, you are bound to declare that act to be invalid. What are you going to do about that, sir?
Do you want to make any further submissions which you've not already made in respect of the matters set out in the registrar's notice to attend?
Why do you keep referring back to that? Are you trying to mislead this court, sir?
I'm asking you if you have any further submissions, and if you don't proceed with any further submissions, I'll take it that you don't have any further submissions.
You won't take anything that's not put before the court. You're supposed to be unbiased. The issue before the court, sir, is the Magistrates Court Act, which brought this case to the court, is invalid. Why won't you deal with it? You must declare it invalid.
Mr. Blue, you're not prepared to make any, or don't wish to make any further submissions in respect of the
That's not true.
attending.
That's not true. That's not what I said.
All right, well, what do you want to say that you haven't already said in respect of those matters set out in the notice?
I want you to deal with the issue I just put to you of the Magistrate Court Act being invalid, and it is. Are you going to declare it invalid? That's a judicial function. You're bound to, sir. If you don't do that...
You just stop talking for a moment. You have an opportunity to make submissions to the court. You can either do that in a proper, temperate fashion. You can choose not to do that. But you cannot choose to make relevant submissions in an intemperate way. Now, if you want to make any further submissions, and this is the last opportunity I'll give you, you can make submissions directed to the matters which are set out in the registrar's notice to attend.
So that is rubbish. I can make any suggestion, any submissions in relation to this matter, and the submission I've made is your invalidity to sit in this court. You've got to deal with that.
You're satisfied that the number of grounds of appeal have a reasonable prospect of succeeding in the appeals accordingly.
Based on what? There's no submissions from him.
Reasons for decision will be delivered in due course. Still, we need to hear from you. Do you have any application?
It's right to seek a word that we seek our cost of the appeal on an annual basis.
On an indemnity basis. Do you have a minute? What did you say?
No.
Mr. Glue, the respondent has sought costs on an indemnity basis.
There is no submission from this respondent before this court, sir.
I'm sorry?
There is no submission. He's just done one. Where's his written submission to the court? I can't put anything else to this court unless it's in writing. How come he can?
It was unnecessary to hear from Mr. Hilton Barber.
What, based on the fact that this is an unlawful court and you're going to persist with that issue?
We're not going to debate the matters.
It's not for debate, sir. This is an unlawful court, sir.
Do you wish to be heard on the question of costs?
There is no cost. This is an application from the registrar. It has nothing to do with this person.
All right. The order will be
Sir, you can't issue an order.
that the appellant pay the respondent's costs pending upon the registrar's notice to attend.
A registrar is a clerk of a company.
The respondent is fully indemnified for its costs, except insofar as those costs may have been unreasonably incurred or are unreasonable in amount. We'll call the next matter.
Your decision is a fraud, sir.
CB 15 of 2012. Glue and Frank Jasper Proprietary Limited.
There's no appearance on the other side. For Frank Jasper.
You're going to pay me back the $2,031 and you chuck the appeal out without asking to hear it.
If you want to address something while we have the report, you have the opportunity to address submissions in respect to the second matter.
You must be aware, sir, when I file the case against you in the federal court, I'll be filing under 4B of the Crimes Act.
All right, well, there's no appearance on behalf of the respondents, so we will proceed in the absence of the respondents. Again, the matter is brought on a registrar's amended notice to attend. They are the matters which we're concerned with this morning. And again, Mr. Glue, you have an opportunity to make any oral submissions you may wish to make directed to those matters.
Yes, I make application that the application of the registrar be struck out and both matters go before a hearing of a lawful court.
Yes.
Well, you can't hear anything else. There's no one here to put any application to you. So my application is the registrar is incorrect. There is nothing before this court to show that I shouldn't have an appeal. Therefore, that appeal goes through.
Is there anything you want to say in respect to the matters set out in the registrar's amended notice of attend?
Everything in the registrar's notice of attend is unsworn. There is no submissions from her. There is no person to dispute my allegation that it's incorrect. And I submit to you that you put the appeal through as an appeal, as the application is. Because you're a company and that is a contract that you now must honour, which I paid $2,031 for. So,
Do you wish to be heard on the question of whether any of the grounds of appeal and reasonable prospect of succeeding?
all the grounds that were reasonable, every single one of them, including the application. The application set aside would be granted on the grounds there was no appearance by anything to object to it.
Do you want to emphasise why the grounds have subsidy.
There's no necessity, there's no one to oppose it, it should go in and it's complete.
Now, directed grounds, the Mac dealt with in paragraph 7 of your submission.
So you can't question those grounds, there's no one here to put in any submission in relation to those.
Was
You are to adjudicate between each one, not to dictate.
if the court is satisfied that the grounds of appeal have no prospect of success,
You're not the court,
it's
so
not
you're the
essential
judge.
that the insubmissions made on behalf of the respondent. The respondent does not have the opportunity to make submissions because
He hasn't
there's no
bothered to
appearance.
turn up.
So that's not determined of the matter. In paragraph 7 of your submissions,
Yes.
you
Can I have a
say
minute to turn to them, please? Since you're not going to abide by the law.
that I mistakenly assumed that you would have relevant papers before you guys are not to
Thank you. You want to refer to which one?
Paragraph 7 of your submissions, the orders made by the Chief Justice would eventuate in the seizure of property belonging to you contrary to Magna Carta. I didn't understand that.
You can't understand that. If you read Magna Carta, sir, that's a question of an insult.
You mean that the judgment,
Nobody can be deceived of their property or anything without the lawful judgment of their peers. Wayne Martin refused to grant me a trial by jury, which I was entitled to have, yes.
I see,
That's a lawful submission, sir.
so that is a contention that the orders were not properly made and therefore are not enforceable.
There wasn't any orders made by a lawful judge, so they can't be enforced anyway. They're contrary to Magna Carta anyway.
All right. Is there anything else you want to say in respect of the matters which are subject to the registrar?
Yeah, the first submission, I want to deal with that.
I'm sorry?
The first submission in relation to that appellant submissions. That's before you.
I'm sorry, what are you referring to?
Paragraph 1, the appellant submissions.
Yes.
Wayne Stewart Martin admitted on the 21st of June 2011 in the Supreme Court of Western Australia that he had not sworn an oath of allegiance and was not required to do so.
Yes. You want to expand on that?
Stand on it.
Expand on it.
Justice Kirby ruled in the Ford's decision, HCA 44 of 2006, paragraph 268, not only permanent judges but temporary judges must swear the oath of allegiance before taking the oath of office. Wayne Martin didn't do it, that's a fraud.
Yes, is there anything else you want to say?
No, no.
But if there's another disturbance like that, I'll have to call it clear. Is there anything further you want to say in relation to the matters subject to
For
the
that particular matter, no. The next matter, paragraph 2. Wayne Martin stated on the 21st of June 2011 in the Supreme Court of Western Australia that he was bound by decisions of the High Court of Australia and the Commonwealth Constitution Act. And then went on and decided that he wasn't bound by it after all. Dr. Material responsive. Sorry.
You can see where judges come from. They were lawyers.
Bain versus Morrison, HCA 29, 2009, backs up that statement. Had there been no Chapter 3 in the Constitution, it may be supposed that some, at least, of the legislative powers would have been construed as extending to the creation of courts with jurisdictions appropriate to the subject matter of the power. But the existence in the Constitution of Chapter 3 and the nature of the provisions it contains make it clear that no resort can be made to judicial power except under or in conformity with subsection 71 through 80. At 48, the only judicial power which the Constitution recognises is that exercised by the branch of government identified in Chapter 3. Forge versus Australian Securities Investment Commission, HCA 44 of 2006. That's 63. That's Michael Kirby again. Because Chapter 3 requires that there be a body fitting the description of the Supreme Court of a state, it is beyond the legislative power of a state so to alter the constitutional description. At 78, in particular, the Supreme Court of a state must be and be seen to be institutionally independent and impartial. Well, how can that be when you work for a company? At 121, in Australia, the ultimate foundation for the judicial requirement of independence and impartiality rests on the requirements of an implication derived from Chapter 3 of the Constitution. At 122, the Supreme Court of a state enjoys a special status and role in the federal Constitution. At 179, the function of the Constitution is the instrument of government for the entire Australian nation. At 269, I've already done that. Cable versus Director of Public Prosecution, HCA, CLR 189 and 1996. Every court in this country is part of the federal judicial system with a High Court at its summit, which means you must sit under Chapter 3 of the Constitution. Wayne Martin said he doesn't. So if he doesn't sit, he sits under state law and statute law. That's a good dream. He is required to sit under Chapter 3 of the Constitution to comply with the provisions. That's the law, sir.
Yes, is there any further submissions you want to put in relation to the grounds?
Yes. Paragraph 3. Wayne Stewart Martin on the 21st of June 2011, the Supreme Court of Western Australia stated that he did not sit under Chapter 3 of the Federal Constitution. He sat under state law, being the Supreme Court Act of Western Australia 1935, as amended. The problem with that is, he's not an officer of the Crown. He's an employee of its own company you are. And all companies, internal and external, are legislative authority of the Federal Parliament. That's Section 51, subsection 20 of the Constitution. And it goes as far in the annotated one to say companies formed on state legislation must form up on the federal legislative authority. Page 657 of the Constitution, the last two paragraphs state quite clearly that all companies, all of Section 51 rather, is the legislative authority of the Federal Parliament exclusively. Not what Wheeler ruled in 2006, that the state can rule in relation to corporations and everything else. They cannot. Therefore, this court, or well, put it this way, the judges and occupants of this court, which belongs to us, are employed by a company. You can't sit under an act of this state. You must sit under the Corporations Act. Where in the Corporations Act does it give you authority to sit in a court and sit in judgment of anybody? You explain that, sir. This is not legal advice. It's a fact of law. You were found as an employee of the company, and you are. The document in my hand, you prove that. It's got an ABN number on it. It's Joe Blow trading as whoever the hell Joe Blow is, but at the end of the day, you're a company and you are bound by the Corporations Act and federal legislation, and there is none to say that you can sit in a judicial function, nor can you. Michael Kirby ruled in Sydney City Council versus Reed. Officer of a corporation cannot be an officer of the Crown. If you want to sit in judgment of me as sovereign subject of the Crown, you must be an officer of the Crown. All prosecutions must be brought under the Crown. That's on page 702 of the Constitution. So that leaves this court without any authority. When it was requested by Wayne Martin that Wayne Kenneth Blue represent his company, Wayne Stewart Martin refused, knowing that Wayne Kenneth Blue did not have the money to pay a lawyer. Wayne Stewart Martin then ordered that the company stand trial without representation, which puts the company and Wayne Kenneth Blue as the managing director into slavery. Contrary to Section 268, subsection 10, 11 and 12 of the Crimes Act. That puts Mr Martin in line to go to jail for 25 years plus 17 plus 17. I hope he brings his toothbrush to the court case that's going to insure in relation to this matter. And that's not a joke or an insult. Number 5, when it was requested of Wayne Stewart Martin to remove himself from the case because he was involved with the lawyers for the plaintiff in a high-profile case just before coming into justice in the Supreme Court, he refused, stating that he ruled that he was not biased in any way. The case he was on was Riddout versus the Commonwealth, the one where he, after losing the case, jumped over every other judge in the state to become the Chief Justice. I wonder what happened there. Anyway, he showed nothing but complete bias throughout the case. He overlooked evidence when it was revealed to him that evidence of one of the witnesses was totally removed and replaced with a load of rubbish which proved the other people's case, contrary to the evidence given by the person, which was Frank Jasper Sr. He ignored it. That's a criminal offence. What are you going to do about that, sir? Probably Section 48, subsection 4 of the State Criminal Code binds me to reveal that to the court. If you don't do anything about it, you become party to the same offence, sir. And the penalty to you is obviously a double under the Act. When Wayne Furness Blue requested a trial by jury in accordance with the Supreme Court Act of Western Australia and Section 80 of the Commonwealth Constitution, Wayne Martin took counsel with Mark Blundell, the lawyer for the plaintiff, and they decided that Wayne Furness Blue could not have a trial by jury because there was too much paperwork. And that's the statement he made. It's in the transcript. I've never heard so much garbage in all my life that a judge of the Supreme Court, or a purported judge, would use such a ridiculous statement. Sir, it is obvious, if this goes to a full hearing, that whoever sits on the full hearing will have to bind Wayne Stewart Martin over the stand trial for fraud, perverting the course of justice. The transcript proves it, and I submit the application by the registrar is an attempt to pervert the course of justice, so that Wayne Stewart Martin does not have to stand trial. He can't say he wasn't aware that the transcript was changed because in a recent submission to him, I revealed exactly what it was, what was said, and that he should do something about it. He didn't even refer to it in his judgment because he knew if he did, he would be admitting to committing a criminal offence, and by his silence he has tacitly agreed to the fact that it was altered. And you must deal with that, sir. Otherwise, under Section 48, subsection 4 of the Criminal Code, you become party to that offence as well. Are you willing to take the chances on that?
Now, you make your submissions in relation to what's said in paragraph 7 of your submissions, although they don't appear to be in the grounds of appeal. I assume you rely upon what's in paragraph 7 of the submissions.
I would suggest, sir, that a registrar doesn't have the power to decide what I put to the court. And she's trying to strike out my appeal. My appeal contains not only the grounds, but the submissions. The submissions back up the grounds. If the court doesn't agree with that, well, I'm sorry, but it just happens to be what I'm going to put to the court when this goes to trial, either before this court or before the High Court. This matter's not going to stop here because you decide you can sit unlawfully in our court, sir.
Yes. Did you want to say anything else about the grounds of appeal?
Yes, there's no one to oppose them, so they should go through. You can't oppose them.
Right.
It's all right.
The appeal will be dismissed.
I beg your pardon.
Arrest the judge.
Security.
There's enough people here to form a grand jury.
Imposter.
He is a quorum.
Arrest the judge. Quorum. Down court, we're not going anywhere.
You're going to arrest him? I am talking to you.
It's just a room with the name on it.
It's our court, you leave. You leave, it's our court.
asking everybody whether to leave this place now.
We're on the coppers here. Federal cops, federal cops.
They won't come.
Get the federal police.
In this court.
Federal police now.
That lying fraud is not going to get away with it.
You blokes are a police force organised by the state government. Whether you like it or not.
No, Serco is a private owned
Sorry, an
company.
army organised by the state government. And state governments do not organise an army.
Get the ID details of everyone. Get their card numbers.
It is. It is.
Well, I can't read it from here. Well, I mean, well, okay, I didn't read the request, but I believe you are required to details.
If you want to come and look and you write it down, you're more than welcome.
Would you leave our court, please?
No, you stand.
Get the federal police.
This is my authority. They remain in court until the federal police come here. If you want to argue with me, you work for a company, I'll have the charge. I'm a Commonwealth public official. If you want to deal with that, try it on.
You want to leave the federal police?
I want the federal police here. The two judges arrested for fraud.
You want me to
treason and contempt of this court.
Wayne, do you want me to ring?
They're written now. Written now. Leaving until the federal police arrest. So I have the authority to deal with it, and I'm dealing with it.
You guys must realise too.
It's not going to stop there. It's going to end up in the High Court. You intervene, you'll end up there with
You must realise too.
practice to stop him.
When you do your job, private company. We're the public, we're the people. This is our court.
You're not a public servant, she's employed.
Corporate. Yeah.
Employed by the state of Western Australia or a company. It's an unlawfully employed by an army. And that's how it must stay, and do not insult them, it's not their fault. They're just doing their job, but it is our job and my right to remain neutral. You will understand, I'm only exercising my authority and rights as a Commonwealth public official, signed, stand, on the court of practice in England, under the government of the Queen. And argue that, there's what the federal police are arguing. But you need to stay here on my authority. If I don't like it, well, that's tough. I'm sorry that I have to stand, I want the federal police here, but I'm going to go to be locked up. They're criminals.
Not just them, either. Thanks for those ones doing me.
Yeah, and all geared together. I know this guy. I'm in a predicament with this going on.